Welcome to Lock and Load Podcast. My name is Josh, where we talk to you about Connecticut 2A issues. Today, we are talking about probably the most important Connecticut 2A issue, which is Grant versus Lamont, and what just happened in the Second Circuit Court of Appeals today, August 22nd, 2025, where we were just denied, lost our appeal in the Second Circuit. So this consolidated two cases, National Association for Gun Rights versus Lamont and Grant v. Rovella, Rovella, if I did not say that correctly. The plaintiffs, individuals in the Second Amendment groups like CCDL and other groups, challenged Connecticut assault weapon bans and large capacity magazines, and they asked for a preliminary injunction to block the enforcement on these laws, arguing that they violated the Second Amendment. So the laws that this was going after was the original 2013 assault weapon ban post Sandy Hook that created an assault weapon ban list and a definition for an assault weapon, and also the 2013 HB 6667 where anything with a AR style, so CT others, is what this also was going after as well. Together these laws made it illegal for most people in Connecticut to buy or possess AR-15 type firearms, many others, and magazines over 10 rounds unless grandfathered in, which even that is significantly hard to do. So the court's ruling, the Second Circuit Court affirmed that the lower court's denial of the preliminary injunction down in New Haven means that laws remain in effect during litigation. Key points: Second Amendment scope. The right is an individual but not unlimited. Following Heller and Bruin, courts must analyze gun laws under history and tradition. In common use argument was rejected. Plaintiffs argue that AR-15 and standard capacity magazines are common, so they must be protected. The court said common use alone is not enough. Weapons can still be restricted if deemed unusually dangerous. Historical analogy. The court cited past restrictions on Bowie knives, percussion pistols, and other lethal and misused weapons. Concluded Connecticut bans are consistent with history, targeted restrictions on unusual dangerous arms, leaving other firearms available for self-defense. And then balance of public interest. According to the court, the plaintiffs did not show that public interest weighed in their favor. The court emphasized public safety and the state's interest in preventing mass shootings. Oh, note on that one. When was the last time there was a Pro 2A rally? Oh, I can tell you that one. That'd be September 30th, 2023. It was an open carry rally that was poorly attended at the Capitol. And why do I know this? Because I was there. The one before that, I have no idea. I can't even tell you. So not showing enough public interest. I could agree with that. There isn't. What this usually means. The ban stays in place. No injunction was granted, so the CT assault weapon ban and large capacity magazine ban are fully enforceable. Appeal process, plaintiffs could try to take this to the Supreme Court, but for now, the Second Circuit sides with the state. What a surprise. And we have a problem here. And the problem is the legal reasoning shift. The court leaned heavily on the reinterpretation of dangerous and unusual, treating it as unusually dangerous. This gives states more room to regulate weapons they see as excessively lethal, even if millions are owned. The bottom line here is the court said that AR-15 and anything that holds more than 10 rounds may be common, but because they're unusually dangerous, Connecticut restrictions are constitutional. The plaintiff didn't show likelihood that they're going to succeed under the Second Amendment framework. Until a higher court rules otherwise, the Connecticut ban remains in full effect. Pretty disappointing. What are your thoughts on this, guys? Comment below. This is not the end of the video, but what are your thoughts on that? Did you think the Second Circuit made the correct decision? If you're watching this video, you probably didn't, but I don't know who this reaches. It would have been really nice if they flipped that, even for a little bit, on a Friday. Could have had a nice freedom weekend, right? That would have been cool. So I have another piece of paper here. So Eddie Grant is the one that sent me this. I'm going to try to get this video out for this evening on the 22nd. See how quick I can get this edited. But Judge Nathan is another person on the Second Circuit Court of Appeals. Now, he also agreed with the majority, but something important here that he decided to write his own dissent on this. The main opinion by Judge Walker said Connecticut bans are constitutional because AR-15s and large capacity magazines are unusually dangerous weapons, even if they are common. The court affirmed that the Second Amendment does not protect every popular weapon, even if history shows restrictions on weapons deemed especially dangerous. What the judge adds is clarification on one key issue: dangerous and unusual versus unusually dangerous. Notice we're taking out the word "and" here. Plaintiffs argue that only weapons that are both unusual and dangerous can be restricted. Since AR-15s are common, The ban must be unconstitutional because they're not unusual. Nathan said this misreads history. The phrase in Heller, dangerous and unusual, was actually quoting or paraphrasing older sources like Blackstone Commentaries from 1769, which used the phrase dangerous or unusual. Historical laws don't focus on whether a weapon was common. They focus on whether it was terrifying and disproportionately dangerous to the public. History shows concern with public terror and not popularity. Some old laws banned going armed in public with weapons that terrified the people, regardless of whether they were common. Some examples of banned weapons in history is like swords, armor, sticks, stones were very common, but were still regulated when used in ways that caused fear. Why it matters. The judge emphasizes the Second Amendment test must follow actual history, not latch on to the word and in Heller. I wholeheartedly disagree. That is case law. And the word and is not the word or. And just because you're a left judge doesn't mean you get to rewrite the Constitution into what you decide. The correction standard is whether weapons are unusually dangerous, not whether they are both dangerous and uncommon. Bottom line, the concurrent strengths with the majority reasoning, AR-15 and large capacity magazines will still be restricted if millions own them because the law allows weapons deemed especially dangerous to public peace. It rejects the plaintiff's view that popularity alone makes a weapon protected by the Second Amendment. In short, Judge Nathan says plaintiff's argument based on the word and in Heller's historical is wrong. The way to read the tradition is usually dangerous, which supports Connecticut's ban. I don't care how he's interpreting it. It's written and. So he's interpreting it without the word that it's written? How does that make any sense? I don't get how we allow judges to influence the Constitution like this, how using their political views, because that's what this is. This is their political views being pushed onto millions of people, millions upon millions of people. New York, Connecticut, and Vermont is the Second Circuit Court of Appeals. So what do you guys think is going to happen next? So this was an injunction to kind of put a pause on the assault weapon ban while the case was heard. So it wasn't the case is dead. It was putting a pause on the law while the case is heard. Does CCDL and Second Amendment Foundation push this to the Supreme Court as an appeal? Or do they just try to push the court case through New Haven Superior Court to get it to Second Circuit Court of Appeals to then get the actual court case to the Supreme Court? Because if the Second Circuit isn't going to agree with us now, are they going to agree with us in the actual court case? Doesn't look like it in my opinion, but I'm not a lawyer. I'm just reading you a brief of the 60 to 80 pages that I was given 2 hours ago now by Eddie Grant. So I want to get this content out there as soon as possible for you guys. I'm going to try to get this uploaded, I think, by tonight, maybe 6 or 7 o'clock. So comment below. Like the video, guys. I stopped what I was doing midday here to go make this podcast so you guys could get this information. So please like the video at a minimum. If you're not already subscribed, please subscribe. Hit the little notification bell and comment below. And I'll answer you guys in the little comment section there. So my name's Josh. I own Lock and Load Firearms. Come check us out, guys. And we'll see you guys next time. Bye-bye. Lock and Load Podcast is sponsored by Lock and Load Firearms, Connecticut's #1 rated gun store and pistol permit class on Google. Come check us out, 1573 Meriden Waterbury Turnpike in Southington. Lock and Load Firearms.
Lock and Load Podcast is also sponsored by Patriot Wear Holsters, custom-made Kydex holsters locally made in Waterbury, Connecticut. www.patriotwearholster.com and use code LNL Podcast for 10% off your purchase. Orders available for shipping or pickup at various locations.